Define bailable and non-bailable offence. As per section 2 of CRPC 1978, bailable offence means an offence which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force. In bailable offences, bail is a matter of course. Police officers, courts, magistrates, session judge, high court may release a person on bail. Example, mischief, house, trespass, etc. are bailable offence. Non-bailable offence means any other offence. In non-bailable cases, bail is not allowed, but a person may be released on bail under certain circumstances. Section 437. In offences punishable with death or imprisonment for life, there is no bail. Example, in murder, rape, etc. are non-bailable offence. What are cognizable offences? As per section 2C of the CRPC, cognizable offences are the offences in which the police can arrest a suspect even without an arrest warrant. These are the serious kinds of offences in which the punishment is more than 3 years with or without fine. Whether a particular offence is cognizable or not is mentioned under the first schedule of CRPC. Crimes like dowry, murder, rape, etc. fall under this category. These are the wrongs done against society, that is against the public at large. The first information report is registered only in cognizable crimes. A police officer is bound to register an FIR in case of a cognizable crime. In cognizable cases, police can make an investigation without prior permission of a magistrate. What is non-cognizable offence? Non-cognizable offences belongs to the category of offences as per CRPC in which police can neither register the FIR nor can investigate or effect arrest without the express permission or directions from the court. This mostly include minor offences such as abusing each other, minor scuffle without injuries, intimidation, etc. It is defined in section 2I of the CRPC. In non-cognizable offences, when the information is given to the police officer, sub-inspector, he should enter the substance of information in the police diary and refer the informant to the magistrate. He should not start the investigation without the orders of the concerned magistrate, but on receiving such an order, he may exercise the same powers in investigating as in cognizable cases. Warrant case. Warrant case under the code of CRPC is a case relating to an offence punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. These cases are usually serious or grave offences that are considered cognizable, allowing the police to make arrest without a warrant. A court of session tries the most severe warrant cases while magistrates handle the rest. Warrant cases can be instituted by filing a FIR in a police station or before a magistrate. The stages of trial in warrant cases are outlined in section 238 to 250 of the Code of CRPC. Chapter 19 of the CRPC governs the trial of warrant cases. The essential elements of a warrant case include: charges must be specified in a warrant case. The personal appearance of the accused is mandatory. Warrant cases under CRPC cannot be converted into summon cases. The accused has the right to examine and cross-examine witnesses multiple times. The magistrate must ensure compliance with the provisions of Section 207 of the Code of CRPC. Section 207 of the CRPC 1973 mandates the provision of copies of relevant documents such as the police report, FIR, and recorded statements to the accused. What are the different classes of criminal courts and their powers? Different classes of criminal courts in India are Supreme Court. The Supreme Court is the highest court of appeal in the country and enjoys the most expensive discretionary and plenary powers in the cases of appeals. High Court, there is a High Court for every state. The High Court has the power to quash the FIR, any investigation and any criminal proceedings before any High Court or any other subordinate court. It also has the power to secure justice to everyone who comes before the High Court and also providing justice in such a way the abuse of the law cannot take place before the High Court. Other courts below the High Court, following criminal courts are constituted. Number 1, Session Court. Number second one is first class judicial magistrate, and in metropolitan area it is metropolitan magistrate, judicial magistrate 2, second class executive magistrate. The judicial magistrates and executive powers. Magistrates are given different and distinct functions and powers under the CRPC. Judicial magistrate of second class has a power of maximum punishment of 1 year and a maximum penalty of 5,000 rupees. Whereas first class judicial magistrate has maximum punishment of 3 years and he can give imprisonment maximum penalty of rupees 10,000. Chief judicial magistrate can give maximum punishment of 7 years and maximum penalty in rupees of no limit. Assistant session judge, maximum punishment is 10 years imprisonment and maximum penalty does not have any limit. Session judge and additional session judge, they both have the same powers and has the power to give any punishment provided by the law and can pass any sentence within the ambit of law. When the session court gives any death penalty, the same needs to be confirmed by the High Court and the sentence shall not be executed unless it is confirmed by the High Court. Now tell me what are the any four rights of arrested person. The rights of arrested person are right to medical examination. According to section 54 of the CRPC, an arrested person has a right to undergo medical examination. According to section 54(2), the report of such examination shall be furnished by registered by the medical practitioner either to the arrested person or to the person nominated by that arrested person. Information on the right to bail. A police officer who is arresting a person for offence is required to inform the person arrested about their right to bail, that they are entitled to bail as per provision of law, and that they can arrange for sureties on their behalf. There is no detention for more than 24 hours. According to section 56 of the Code of CRPC, an arrested person must be brought before a magistrate immediately. If the police official fails to produce an arrested person before a magistrate within 24 hours of the arrest, the police official shall be held guilty of wrongful detention. Right of free legal aid. The Supreme Court in the case of in Khatri 2 versus the state of Bihar has held that the state is under a constitutional obligation implicit in Article 21 to provide free legal aid to the indigent accused person as is implemented in Article 21 of the Constitution. Next question is, what is summons? A summons is a legal document issued by the court directed to a person to appear before a judge or a magistrate. Section 204 of the CRPC empowers a magistrate to issue a summons in a summons case. The summons must be in a writing, served in duplicate, signed by the presiding officer of the court issuing it, and bear the seal of the court. What is warrant? A warrant under the Code of CRPC is a written document issued by the court to compel the appearance or arrest of any person or search any place that the court requires. A warrant of arrest must be in writing, signed by the magistrate, and bear the seal of the court. Section 204 of the CRP allows a magistrate to issue a warrant in a warrant case. A warrant under CRP is a legal document that authorizes the arrest of a person who is charged with a serious offence. A warrant must contain the name and other details of the person to be arrested, the offence for which the person is charged, and the authority given to the person who executes the arrest. Now let's distinguish between summons and warrant. A summons is a written order issued by the court compelling an individual to appear before the court at a specified time and place. A warrant is a legal document issued by a magistrate or judge which authorizes the police to arrest someone. Summons is generally used in cases where the offence is not of serious nature. Warrants are typically used for more serious crimes. The person to whom it is directed is duty bound to appear before the court. A warrant of arrest must be in writing, signed by the magistrate, and bear the seal of the court. The person named in the warrant is to be arrested and produced before the court. The failure to comply with the summons can result in penalties. Next question is, what is FIR? An information of a cognizable offence recorded by the police office under section 154(1) of CRPC is commonly known as first information report. An information of a cognizable offence under CRPC 154(1) is known as FIR. Though this term is not used in the Criminal Procedure Code, it is the earliest and the first information of a cognizable offence recorded by an officer in charge of a police station. It sets the criminal law in motion and marks the commencement of the investigation, which ends up with the formation of opinion under section 169 or 170 of CRPC as the cause may be, and forwarding of police report under section 173 of CRPC. FIR is not a piece of substantive evidence. It can be used only for limited purposes like corroborating under section 157 of the Evidence Act or contradicting the maker thereof. What is police diary? The police officer doing investigation should maintain a diary and record the time of reception of FIR, the time of beginning and closing of investigation, places visited, a statement of circumstances. Any criminal court may call for the police diaries of a case under inquiry or trial in such court and may use such diaries not as evidence in the case but to aid it in such inquiry or trial. Neither the accused nor his agent shall be entitled to call for such diaries, nor shall he or they be entitled to see them merely because they are referred to by the court, except when it is used by the police officer to repress his memories or if the court uses them for the purpose of contradicting such police officer. What is zero FIR? A zero FIR is a first information report that can be filed in any police station irrespective of the place of incident or jurisdiction. This means that a person who has information about the commission of a cognizable offence can file an FIR at any police station, and it is not necessary to go to the police station within whose jurisdiction the offence falls. The officer in charge is required to record the FIR and then transfer it to the appropriate police station where the offence occurred. This provision is particularly useful in cases where the crime has taken place while the victim was in transit. What are compounding offences? Offences are grouped into compoundable and non-compoundable. Provisions relating to compounding are given in section 320 of CRPC. Compounding means making a compromise. These offences are situations where the harmed person, the person who made the complaint called the complainant, decides to withdraw the accusations against the persons accused of the wrongdoing. Compromise may be made with permission of the court or without the permission of the court. Compounding is allowed because the complainant and the accused may make some compromise within themselves, that is, they agree to settle their differences mutually. Compromise once made cannot be withdrawn. It can be made at any time before the sentence is pronounced by the court. The offences which are to be compounded with the permission of the court, example, theft, value below rupees 250, cheating, cheating by personation, bigamy, insulting the modesty of a woman, etc. In cases of hurt, assault, criminal trespass, defamation, etc. mentioned in the CRPC, the offences are compoundable without the permission of the court. The offences which are to be compounded with the permission of the court: insulting the modesty of a woman, bigamy, cheating by personation. Okay? In these cases, the permission of the court is required, whereas in the other cases like hurt, assault, the compromise can be done or the compounding can be done without the permission of the court. What is double jeopardy? One fundamental principle of criminal law is that no person who has been accused of an offence should be prosecuted and punished for the same offence more than once. The principle is contained in Article 22 of the Constitution and also in Section 300 of CRPC. The origin of this is in English law, nemo debet vis vexari, that is, no one shall be vexed twice. According to this, if a person has been prosecuted and convicted, and the accused should not be tried again by any court in India for the same offence. What is public prosecutor and assistant public prosecutor? A public prosecutor is a state representative who is a law officer chosen by the state or central government to represent the interest of the public. A public prosecutor is appointed under section 24 of CRPC. A public prosecutor participates in the process of investigation and during the trial. The state government has the power under CRPC to appoint public prosecutors at the High Court level, at a district court level in consultation with the High Court and the Sessions Court. The district magistrate prepares a panel of names who are fit to be appointed as public prosecutor. The minimum qualification is at least 7 years practice as an advocate. The public prosecutor is a public servant. Assistant public prosecutors are appointed by state government in each district for conducting prosecutions in magistrate courts. No public officer below the rank of a police inspector and who has made an investigation in the case can be appointed as assistant public prosecutor. Office of the APP is the creation of the new CRPC. APP may appear before magistrate court. He is not under the control of the police department. What is arrest? The common definition of the word arrest is the deprivation of one's personal liberty. Neither the code of the CRPC nor any other significant substantive law defines the term arrest. A person is considered to be arrested in a legal sense when they are taken into custody by a law enforcement officer with the intent of holding them for trial on a criminal charge or preventing them from doing an illegal act. What is petty offence? Petty offence means any offence punishable only with fine not exceeding 1000 rupees. Petty offence means any offence punishable only with fine not exceeding 1000 rupees, but does not include any offence so punishable under the Motor Vehicles Act 1931 or under any other law which provides for convicting the accused person in his absence on a plea of guilty. It does not include any offence so punishable under the Motor Vehicle Act 1931 or under any other law which provides for convicting the accused person in his absence on a plea of guilty. What is anticipatory bail? Anticipatory bail or a pre-arrest bail is a legal provision that allows an accused person to apply for bail before being arrested. In India, pre-arrest bail is granted under Section 438 of the Code of CRPC 1973. It can be issued only by Sessions Court and High Court. The provision of pre-arrest bail is discretionary and the court may grant bail after considering the nature and gravity of the offence, the antecedents of the accused and the other relevant factors. The court may also impose certain conditions while granting bail, such as surrendering the passport, refraining from leaving the country, or reporting the police station regularly. What is charge under CRPC? As per section 2B of CRPC, charge is defined as charge includes any head of the charge when the charge contains more head than one. Charge is accusation made against person in respect of the offence alleged to have been committed by him. What is complaint? As per section 2D of CRPC, a complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under this code, that some person, whether known or unknown, has committed an offence but does not include a police report. Who is probationary officer? As per the Probation of Offenders Act of 1958, a probation official is a court officer who regularly meets people sentenced to a supervised probation period who are generally the perpetrators and lower level criminals. The majority of the offenders placed on probation are first time offenders. Placing anyone on probation is a way for the court to prevent offenders from imprisonment. Many that are on probation live in our neighborhood, stay home or working or participating in an educational program and raise their children. The justice system's objective is to have a person who is put on probation as a responsible member of a society while retaining contact with his or her family and community support sources. A probation officer will need to meet on a monthly or sometimes weekly basis their client based on an assessment of risk needs. The probation officer may decide the degree of supervision that a person requires, minimum, medium, or maximum. It helps to determine how much assistance a person requires. Probationary officers work at city, country, and state levels and have legal and sociological training in rehabilitation. While the majority of the public consider probation officers as merely supervisors of offenders, their role within legal system is significantly broader and more complex. Most probation officers do not get involved only after the probation sentence has been handed down but may provide input to prosecutors, judges, and courts officials long before the trial begins. In many jurisdictions, probation officers also adopt the role of parole officer, which oversees the re-entry of ex-convicts into society. What are the duties of probationary officer? The duties of a probationary officer under the Probation of Offender Act 1958 as laid down in the section 114 of the Act include investigation. The probation officer conducts an investigation to gather information about the offender and the circumstances surrounding the offense and submit the report to the court. Supervision and surveillance. The probation officer supervises the offender during the probation period to ensure compliance within the conditions of probation. Counseling. The probation officer provides counseling to the offender to help them understand and rectify their behavior. Exercise of professional control on the delinquent probationers. The probation officer exercises professional control over the offender to prevent them from committing further offenses. The Act aims to save minor offenders from becoming regular criminals by giving them the opportunity to change for the better rather than going to the jail. The probation officer seeks to resolve the issue amicably while attending to the needs and challenges of the accused. What is admonition? Admonition under the Probation of Offenders Act 1958 is a stern warning or reprimand. Section 3 of the Act deals with the power of a court to release the offender after admonition. The section empowers the court to release the offender without undergoing the penalty prescribed by the Indian Penal Code or any other relevant law. In essence, it's a way for the court to give the offender a chance to reform without serving a traditional sentence. What are heinous offences? Heinous offences, as per the definition, are given under Section 233 of the IPC and also as per Juvenile Justice Act 2015 are those offences for which the IPC or any other criminal law for the time being in force prescribes terms of imprisonment of 7 years or more. What is conviction and what is acquittal? Conviction means that when the trial ends, one has been proven guilty of a particular crime and accordingly judgment of punishment are as per law is passed. Acquittal means the prosecution was not able to prove that one committed a crime. An order of acquittal is also in the nature of judgment. What is public nuisance? As per section 280 of IPC 1860, a person is guilty of a public nuisance who does any act or is guilty of an illegal omission which causes any common injury, danger or annoyance to the public or to the people in general who dwell or occupy property in the vicinity or which must necessarily cause injury, obstruction, danger or annoyance to persons who may have occasion to use any public right. Therefore, it is a crime against society and not just against an individual or a group of people. For instance, polluting water streams, obstruction of highways and storing explosives are examples of public nuisance. What is judgment under CRPC? A judgment is in the context of the code of CRPC is the final decision given by a court at the end of a criminal trial. Although the term judgment is not explicitly defined in the CRPC, it is generally understood to be the final order of the court. Chapter 27 of the CRPC 1973 deals with the judgment. It explains the meaning and procedure of passing judgment by a criminal court. A judgment should clearly mention the reason for accepting an argument and rejecting the other. Section 344 of the CRPC outlines the language and contents of the judgment. Section 354 of the CRPC outlines the language and the content of the judgment. It states that every judgment in a criminal case should be written in the language of the court, contain the points for determination and the reason for the same, specify the offense and the reason for the same, and mention the Indian Penal Code or any other law under which the crime is committed and the punishment is given. In essence, a judgment is the expression of the opinion of the judge or magistrate arrived at after due consideration of the evidence and the end of the arguments. What is Children's Home as per Juvenile Justice Act? Under the Juvenile Justice Act 2015, children who are in need of care and protection can be placed in a child care institution. The types of child care institution include children home, open shelter, observation home, special home, place of safety, specialized adoption agency, and a fit facility. Children homes for boys and girls provide shelter during the process of inquiry and a long-term rehabilitation for orphan and destitute children in need of care and protection. Section 34 of the Juvenile Justice Act 2000 states that the state government may establish and maintain children's homes in each district or group of districts. The children's home is a home where children in need of care and protection are placed on the order of a competent authority. This